Okay, turn off that time, clear it. Okay, we have Council Spinner and Curry. Oh, what a wonderful world technology is when it works. Okay. Mr. Spinner, you represent the appellant, and would you wish to reserve any time for your rebuttal argument?
Yes, Your Honor. May I please reserve 5 minutes for rebuttal?
I will make that notation and do my best to not interrupt you at a critical time, but still close enough in time so that you can make a professional judgment whether or not to use the rest of your time or to save it.
Appreciate that, Your Honor.
We are ready to begin, counsel.
May it please the court, Samuel Spinner with Conrad Simberg on behalf of the appellant in this case, Old Dominion Insurance Company. Your Honors, Old Dominion respectfully requests that this court reverse the final judgment in favor of Jeffrey Cook and remand with instructions to enter judgment for Old Dominion because the undisputed evidence conclusively shows that Mr. Cook qualifies as an employee under the underlying policy issued to Gator Creations, and therefore Old Dominion owes Gator Creations no duty to defend and indemnify it from Cook's underlying negligence claim as a matter of law. Your Honors, I think it's important to—
Can I just ask you a question? Because
Yes,
it's hard to say these facts are clear cut. Do we have a temporary employee? Do we have a permanent employee? Do we have a seasonal employee? This is a person who worked on and off for an employer, correct?
Yes, Your Honor.
And he's excluded from coverage if he is a permanent employee, but not if he's a temporary employee?
Yes, Your Honor. The policy broadly defines employee as anybody who is working for the employer. There is an employer's liability exclusion for temporary, there's an employer's liability exclusion for claims by injured employees. There's an exception to the exclusion for claims by temporary workers.
Does any of this require evidence that the person was furnished to the employer? Because you make kind of an argument on appeal, but I didn't see that made below.
Yes, Your Honor. It has been part of our presentation on appeal that because we're looking at a one-sentence policy definition, which is a temporary worker is someone who is furnished to you to substitute for a permanent employee on leave or to fulfill short-term seasonal workload conditions, that this court should not foreclose us from arguing on appeal the entirety of that definition. I recognize that my colleague has raised preservation in their answer brief, and frankly, we believe it would be an overly harsh application of the preservation of error doctrine to foreclose us from raising this issue on appeal. We're talking about a one-sentence policy exclusion, and in this appeal, we have dedicated more time to 3 words, essentially, in that one sentence.
Mr. Spinner.
Yes, Your Honor.
Your client, in arguing before the trial court, the only time it pointed the court or mentioned the text of this of the temporary worker provision was to quote it. There was no briefing about furnished to. The evidence on furnished to is, to me, less than clear, given that Boyden testified that a friend referred him to Cook, and if I understand correctly, Cook's position was that he met Boyden on the street. And those things happened in 2014, which was a project that was done. Cook worked on a project, and 2 years later, he shows up for these successive projects that culminate in this injury before the second one was finished. So there are a couple of gaps in here. And now we don't have the benefit of a transcript that would show, certainly your client could have made a legal argument at the summary judgment hearing, but we're here to review an error of the trial judge, which, how does the trial judge err if he doesn't know that this is an issue? And I understand what you're saying, that it's all in one clause, one provision of this policy, but ultimately this becomes a big part of your appellate case, and the trial judge had no idea that this is what was going to become the focus of an error analysis. So I'm struggling with preservation.
Understood, Your Honor. And if I can briefly correct just one factual assertion there, is that it's not disputed that Mr. Cook was referred to Mr. Boyden in 2014. It was in 2016 that they met each other walking down the street. So those were 2 different, I don't believe that that is conflicting testimony. I believe that the testimony is referring to one period of employment and then referring to the second period that began in 2016.
So your position on the evidence regarding how Cook and Boyven got together is that for the first job, he was referred or furnished. And for the jobs at issue here, or the first job that led to the second job, they just ran into each other on the street. So there's a temporal distinction between the furnished to occurrences.
Correct, Your Honor. It's undisputed that Mr. Boyven was standing outside of the courthouse where he was attending an unrelated matter, and Mr. Cook was walking down the street, asked him if he had any work, and that is what became what we believe is a second employment relationship, and during which Mr. Cook
But we have no record of this ever being brought to the attention, the trial judge ever having an opportunity to review any, looking at this from the standpoint of whether Cook was furnished to Gator for the 2016 work.
Yes, Your Honor,
Right?
but correct. These were cross motions for summary judgment. The judge granted their motion, and in its order, it found that Mr. Cook met the definition of temporary employer. Our position is that implicit in that ruling is, of course, that the judge found that all of the elements were met. I recognize that it could have been more fully briefed below, but when you look at the preservation of error cases that my colleague has cited, they're usually a party raising an issue that's inconsistent with what they argued below, or an entirely new issue that is completely outside the confines of the issue on appeal. So, for example, in the Sunset Harbor case, you had a party who raised an affirmative defense that something was unconstitutional, a statute was unconstitutional. They briefed that issue, and on appeal, they said, oh, actually, you don't have standing to raise that affirmative defense. Or in the Cheyenne case, they said.
But here's the thing. This is de novo. And most of the time, that preservation and summary judgment cases has to do with what you just said. But is it your position that the de novo review that we look at in summary judgment rulings can be basically a gateway to get to a legal argument that nobody raised specifically, which is what Sunset Harbor requires, a specific direction of the trial judge's attention, that we can reach those as though it's fundamental error on the back end? I don't see anything in the final judgment that focuses on the furnished to issue. So I'd like you to speak to that. And I don't know if your opponent cited our decision in Johnson and Deutsche Bank in the case, but it is a recent decision of this court that I think speaks to the limits of de novo review for legal issues that don't appear to be preserved.
Yes, Your Honor, I'm familiar with the case, and that, it's talking about a gateway to fundamental error arguments. Of course, we're not claiming that this was fundamental error. We didn't raise that on appeal. Our position is that because we're essentially focusing on such a narrow issue of 3 words of the same policy exclusion that was argued below, and because the judge ultimately found that the entire exclusion applied, we believe that implicit in that was a finding as to each of the elements. But even if, for the sake of argument, if this court finds that we can raise the issue on appeal, of course, preservation really only matters in the event that this court finds that the argument has merit. And so if I can address the argument on the merits, we do not believe that Mr. Cook was furnished to Gator Creations in 2016. There is only one reported Florida appellate court decision that talks about the furnished to requirement. That was the National Indemnity versus Landscaping Management case.
And tell me, I've read the case. That case is a 4th DCA decision. And essentially what the court did there was find this language to be ambiguous, this standard provision, and construe it in favor of the insured for greater coverage, right?
Correct, Your Honor.
And the furnished to in that case, which was apparently developed, dealt with whether the employee could be furnished by virtue of an employee of the company bringing, essentially hiring, correct?
Yes, Your Honor.
So I have a question for him and just redirect a little bit. What you're asking for us to do, the remedy that you've asked for, is that we should send this back with the instructions for the trial judge to enter a judgment of no coverage, right?
Yes, Your Honor, that we have no duty to defend and indemnify in the underlying case.
And to support that, you rely entirely on because it's the furnished to piece, you're relying on how you've characterized the evidence of the 2014 and the 2016 encounters to get out of having this guy having been furnished to in 2016, right?
Correct. And of course, we're also still raising the issue of the short-term employment, and we believe that the trial judge got that issue, came out on the wrong side of that issue as well. So
understood. And I just wanted to clear up the question of how we look at this in terms of the remedy that you're requesting and whether there would need to be any further proceedings on the summary judgment evidence. And so your position is no, because under your theory, the 2016 was a street encounter and that's all there is to it. The 2014 is irrelevant. Okay, so I'm sorry I interrupted you. I know you want to talk about what is a short-term worker, so I'll let you get back to your knitting and tell us about that. Thank you.
Understood, Your Honor. And just to clarify one thing, while the 4th DCA found the furnished to language ambiguous, it was only ambiguous insofar as who has to do the furnishing. It was not ambiguous that someone has to be involved in that relationship, a third party. We both moved for summary judgment. We agreed the evidence was not in dispute. I'm not going to speak for my colleague, but neither of us have argued that there are additional facts in dispute. We simply believe that the trial judge came out on the wrong side of the legal issue based on the undisputed evidence that was presented. Obviously, when the same parties are deposed twice, years apart, I think there's a little bit of minor ambiguities, but I don't think there's anything that I would characterize as a genuine issue of material fact that precludes final summary judgment, for better or worse, for one party in this action.
But there's no transcript. How do you get around the lack of a transcript? Do you say it doesn't hurt you in this case because it's all issues of law, or something could have been said or done at the hearing that is thwarting our review of this case?
Your Honor, I don't think that the lack of transcript has any bearing on the short-term employee or temporary worker argument. The case law is pretty clear that you can still review a summary judgment de novo based on the written submissions as it relates to the temporary worker and the short-term aspect of that definition.
What about the furnished argument? You said there was a couple of different factual scenarios that may have been in dispute.
No, Your Honor, I don't believe that the evidence is in dispute, and I can represent to the court that we didn't raise a specific argument at the hearing below. I think the court is well aware of the preservation issue and our argument on the merits insofar as the court is willing to go there. But again, that does not foreclose reversal for judgment in our favor in this case, because the furnished to is simply one part of it. The bigger issue in this case is the short-term nature of
what's the relief you're seeking exactly? Are you reversal for summary judgment in your favor, or reversal for further proceedings? If so, what?
For summary judgment, Your Honor, we don't believe that there's any genuine issues of material fact. We believe that the judge should have made a legal ruling one way or the other on this issue. That was the position that we took in our cross motions. Of course, if the court finds that there are issues of material fact that remain under the declaratory judgment statute, the judge can submit issues to a jury if there needs to be factual clarification. But our position on appeal and below has always been that there are no genuine issues of material fact that would preclude a ruling as a matter of law.
Oh, it was a non-jury declaratory judgment, similar to a summary judgment, but technically it was a hearing on the merits. Is that a fair way to assess it?
I think that's fair, Your Honor, because the only thing we asked for in this declaratory judgment action was a determination that we did not have a duty to defend and indemnify. Ultimately, the final judgment in this case is going to either answer that question affirmatively or negatively.
Okay.
And that's why we believe that that the undisputed evidence simply results in a flipping of how the court found, and that based on the undisputed evidence and how that evidence should have been viewed in light of the case law, in light of the definitions and the policy, that it should have come out in our favor on the issue.
I'm going to get you to the temporary worker and short-term, the short-term workload conditions, which is the text of the policy. So your position, as I understand it, is that because Gator hired Mr. Cook successively and to work on jobs that lasted more than a few days, and he finished the residential job and went to the commercial job, or vice versa, I can't remember which the order is, but that because he worked for several weeks on the first job, picks up the second job that's supposed to last for 5 months, except that he stepped on the nail, that rendered him, and I'm going to ask your opponent the same question, that made him a permanent employee, or, an employee within the meaning of the exclusion versus a temporary worker.
Correct.
Now, these are the jobs that Mr. Cook is doing look kind to me, for lack of a better term, of pretty unskilled demo and cleanup, sort of labor pool day worker kind of jobs, correct?
Yes, Your Honor.
And there was a conflict in the evidence, was there not, as to how Gator paid Cook. I think Cook, one of them said he was paid exclusively in cash, but there's record evidence that he was paid occasionally in checks. And what you want us to find is that even though Gator didn't treat him as an employee, didn't record taxes, didn't buy workers' comp for him, treated him like a day laborer, that he was actually a permanent employee.
Yes, Your Honor, and I think that brings up a very important point, because
As you make your response, you're at 15.
Okay, I will briefly respond and then save the remainder. I think there's a tendency in these cases, because we see the word employee, to get dragged into the realm of vicarious liability and the restatement, and looking at whether an employer is liable to a third party based on the actions of an employee, whether they are or are not an employee or independent contractor. In this case, we're looking solely at the term employee in a commercial general liability policy, which is designed to provide coverage for injuries to the public at large, people who are strangers to the insurance policy. And that is why it so broadly excludes and so broadly defines employee as anybody who is working for the employer. So
I'm going to leave this for your rebuttal, because otherwise Judge Casanova is going to shut my microphone off. But when you come back for rebuttal, I want you to talk to me about why this provision is in CGL policies, and specifically that my understanding of the reason for this is it recognizes that a permanent employee generally qualifies for workers' comp, while a temporary employee wouldn't, and that's why the exclusion and the exception to the exclusion exist. And again, I'm just going to let you think about that so that I don't use up any more of your time or incur the presiding judge's wrath for asking.
He has no wrath.
Understood, and thank you, Your Honors. Do Your Honors mind if I sit at my table that is here, just so that I'm not have to stand?
You don't have to worry about zooming out or whatever. I'm fine with that, and we'll call you when it's time to return.
Okay, I will see you again shortly. Thank you.
Thank you. Okay. Let me stop the clock. Mr. Curry, you don't want to start at 17 or 18. There we go. We are ready, counsel.
Thank you, Your Honors. May it please the court, my name is Lance Curry, and I'm here on behalf of the appellee, Jeffrey Cook. The trial court correctly entered summary judgment in favor of coverage in this case, and I think the heart of the issues is going to get to the short-term workload conditions, but I just want to briefly address the Furnish 2 argument, if I may, but if anyone has a question and wants to direct me otherwise, I'm happy to do that as well. The Furnish 2 argument is clearly waived. It wasn't raised below, and what they're saying is that by generally challenging the applicability of a definition, generally you've preserved all arguments that could have been raised about the definition, and that's just not the law.
I have a question, just to be clear. Can I just interrupt you? By arguing it wasn't preserved, if it was preserved, are you conceding there was a problem with that, or you still win, and if so, why?
Oh, yeah, Your Honor, we absolutely believe that even if it was preserved, the judge summary judgment was appropriately entered in favor of coverage, and I will address that, Your Honor. So the specific legal argument or ground has to be argued to the court on appeal. It's clear from the case law, and this they're acknowledging was not raised below. If their preservation argument were accepted, a party challenging any part of a definition, whether it be in a statute or in a policy, would automatically preserve all unraised arguments regarding the definition. I'll note that even some of the definitions in this policy go on for half a page and have multiple subparts.
Mr. Landis, Mr. Curry, I'm sorry. I would like to, I mean, I think we've killed preservation for the time being.
Fair enough.
I would like to hear your version of how it is that Mr. Cook, who, you know, Gator didn't seem to employ anybody on a routine basis. And I guess Mr. Boyven would, as he got jobs, go find whoever he wanted to do the work that was being done. And if I'm not mistaken, the record shows that on the back end of this, Boyven he changed his practice. But your guy worked for him. Or Mr. Cook worked for him for an extended period of time, certainly on an as-needed basis, but short-term, it seemed in one legitimate or potentially reasonable interpretation of the definition. You know, what does short-term mean? It means short. It means a few days, maybe, you know, a day here or there. But your guy, over a period of a couple of years, is taking jobs with him that last, and the job that he was injured on was expected to last for 5 months. And when he was brought into the job, that was the expectation. So help me understand how we turn him into short-term under those circumstances.
Sure. And Your Honor, I think you pointed out that what we're ultimately going to get to here is there are multiple reasonable interpretations of this language. And that's why the language is ambiguous and has to be construed in favor of coverage. But Mr. Cook, you know, worked for I think that you can look at short-term as a temporal component, but you can also look at it as relative to the industry. Are you being hired for something that's not permanent, like a specific job? So what we know here is Mr. Boyven was referred by his friend to hire Mr. Cook as a laborer, pay him $10 an hour. And just as an aside real quick, Judge, you asked about the cash versus check payment. The testimony is that in 2014, when he was working on that project during the summer, he started being paid cash, and then he was paid checks some during 2014. In 2016, it was cash only, $10 a day. So what happens is he works for Mr. Cook, is hired as a temporary worker just for that job in 2014. And then Gator Creations goes on and has several other jobs. And Mr. Boyven's testimony is, I didn't need him on those jobs. That's why I didn't have him on those jobs. So then we get to 2016, and Mr. Boyven, on behalf of Gator Creations, again hires Mr. Cook for 2 specific jobs. The first job ends up being 1 to 2 weeks for Mr. Cook. He's demoing a wall at a commercial building. And the testimony is that that job actually went on and lasted some longer period of time, but Mr. Cook's role was only for 1 to 2 weeks. And then you get to the third job where Mr. Boyven decided that he needed some help, and he hires Mr. Cook to do demo and cleanup on this job site. And he's expecting it to be about a 3 to 4 month job. And I thought this was very important. When Mr. Boyven testified that at the time Mr. Cook was injured on July 1st of 2016, Mr. Boyven testified that the project, that renovation project, was about 60% done. And Mr. Cook had been working for about 1 month doing cleanup and demolition at that time. And the only reason it went longer, according to Mr. Boyven's testimony, is because the homeowner couldn't make any decisions about what color to paint the wall. That doesn't necessarily mean that Mr. Cook's role on this one project is going to be extended indefinitely.
Well, so I have to ask you this question. Under Mr. Boyven's approach to hiring workers for his construction company, is anybody ever a permanent employee?
I think under Mr. Boyven's approach, what he would do is he tried to do the work himself. That's what the testimony was. And if he had something that he could not do, and this is in the record, I can find you the record pages, he said, I would hire subcontractors if it was a job that I couldn't do, I didn't have the skills to do, or that I wasn't allowed to do, like an electrical job. So
was
he was hired.
Was Gator a license? Did they have a general contractor's license?
No, Your Honor, they did not. But this is how Mr. Boyven viewed his business, how he ran his business. He tried to do the jobs himself, and if he could not do the jobs, he hired subcontractors to come in and do the jobs. And what he hired Mr. Cook and others to do was to clean up for those subcontractors. So he's hiring here and there as needed, when he needed occasional help, to clean up after the subcontractors that Mr. Boyven retained on behalf of Gator Creations. So that's kind of how Mr. Boyven's business model was working at the time. And it's clear, Mr. Boyven, in his opinion, his feeling was Gator Creations had no employees, so he didn't need workers' compensation coverage for anybody. So there was no workers' compensation coverage in this case. I'd also like to address quickly the idea that the speculative testimony that's out there about what might have happened in the future had Mr. Cook not gotten hurt. Well, what you see from that testimony is really the appellants, Old Dominion, cite 3 citations in their briefs about this testimony. And I just want to show the court why that testimony is just not exactly the way it's presented. They first cite to page 317 of the record, where Mr. Boyven is asked, if Mr. Cook had not been injured, would you have kept him on the renovation project? And his answer is, probably would have stayed there to clean up and stuff like that. Again, you have a renovation project that gets extended because the homeowner can't figure out what color to paint the walls and that sort of thing. It doesn't mean that Mr. Cook's role is suddenly going to expand into some sort of permanent employment relationship. 371 to 372 they cite, and this is where Mr. Boyven agreed that Mr. Cook was someone he would have continued to use had he not gotten hurt. That's just in line with the existing relationship. He would have continued to use Mr. Cook here and there as needed for these small projects and small roles. And then the last testimony that they cited was 584 to 585 of the record. And this is where Mr. Cook testified that his understanding was that once the remodeling job renovation was done, Mr. Boyven was out looking for more work, and that Mr. Cook didn't get to do it because he got hurt, but he doesn't even know what that was. None of that establishes, I'm sorry, Your Honor, you want? None of that establishes that Mr. Cook would have been something other than a temporary worker for Gator Creations. He could still be used on and off here and there. There's a couple of...
I understood that argument. I have a question for you, and I'm sure I'm taking you away from your train of thought, so I apologize.
I'm here to answer.
I asked your opponent about the remedy. And my question to you is just hypothetically, if we were to reverse this and send it back, do we have undisputed facts on Furnish 2, or do we have to send this back for factual determinations concerning Furnish 2 and or the further development of factual record on short term?
Well, in the Furnish 2 argument, we've already talked about the argument was waived. So I don't think you get to go up on appeal and say, I want to go back and...
Well, assume that we don't agree with that, just for the sake of argument.
Sure.
Assume that we're going to send it back. And what I'm asking you is your vision for what instructions we provide going back.
Okay. Well, first of all, I would ask that it not go back.
I know you don't want it to go back.
The reason that it doesn't go back under either theory is because the interpretations that Old Dominion is offering you on both the Furnish 2 and the short-term workload conditions, I'm not disputing that those are reasonable interpretations of this policy language. But what we have here is that the countering interpretations of that policy language that we're offering is also reasonable. And the law is clear that that's where an ambiguity exists, right? If you have two reasonable interpretations of the same policy language, there's an ambiguity, and the ambiguity has to be resolved in favor of coverage. That's the clear Florida law, especially where you're dealing with an exclusion like we are here that has to be more strictly construed against the insurer. So on the Furnish...
What we really have is an exception to the exclusion. Right?
Well, it may be a matter of semantics because the question is, does this exclusion apply? And the exclusion applies only to employees, and employees are defined in a certain way as not to include temporary workers. So I accept that. And we're dealing with whether this employee liability exclusion applies. And so going back to the furnished to, the real question that we've gotten to through the briefing is, does this two separate employment relationship idea cut off the referral? There was a referral in 2014, and then he was hired in 2014 and again in 2016. Old Dominion says, no. Policy says it's got to be referred for a specific employment relationship, but the policy doesn't say that. It just says furnished to. If Old Dominion wanted to put in a time limitation or some sort of limit on the exclusion, says it has to be referred for the very next job.
So your position in the scenario that you don't want to materialize is that if it goes back, the furnished to evidence is already there because the 2014 introduction that preceded the initial relationship is established in this record, and it's sufficient to be furnished to from now on.
Yeah, and I think it's important that putting the preservation of furnished to aside, the Old Dominion has not argued that there is a factual issue that needs to be developed on remand. They have specifically argued on appeal, there are no disputed facts and we're entitled to summary judgment. So we'd be sending it back contrary to the wishes of all the parties here on appeal. So I've talked about the ambiguity on the furnished to language. There's also this ambiguity on the short-term workload. We're talking about the workload conditions in the construction industry, and what does that mean? I mean, we understand that short-term means for some sort of definite finite period, but there is no bright line written into the policy language. And if they want a bright line, it can't be more than 5 months, it can't be more than 6 months. They can do that in the policy. They just have to do it using clear and unmistakable language. They didn't do that here. So some of the other testimony that Mr. Cook testified to, I thought was very important. Was there ever, this is from 457 in the record, was there ever any type of understanding that you and Bobby, Mr. Boyden, as to continuing to work with him or for him? No, not really. When a project would come to its end, would you then have the expectation of another job with Bobby or not? No, like I said, he just used me temporary whenever he got in a jam. Is our suggestion that the temporary worker definition applies to this set of facts, is that unreasonable? I would submit that in the construction industry, where they have jobs that take place that go on for years and years on end, construction folks would tell you, we hire people for these day labor jobs that it may take a month, it may take a week, it may take several months, but that does not make that person a permanent employee. And so if we have a couple of different reasonable interpretations of this policy language, one that is in favor of coverage and one that is not, Florida law requires the court to find the policy is ambiguous and you have to attribute it to coverage, find in favor of coverage. So that's exactly what, at the end of the day, Judge Carroll, the trial judge below, did, and I believe would have to do, it had to go back on remand. I mean, essentially, I guess we would call Mr. Cook and Mr. Boyden to testify live. They're the only two witnesses with personal knowledge of this employment relationship, and they both testify that he was only used as a temporary employee for short-term work. So we would ask the court to not send this back, to affirm because the trial court got it right. And if there are any other questions, I'm happy to answer them. Thank you.
Thank you, counsel. Mr. Spinner, you have 4 minutes remaining, sir.
Thank you, Your Honor. May it please the court. Your Honor, the hallmark of short-term employment is a defined or fixed period of that employment. You should be able to ask a short-term employee, when does your employment end? That's what they talked about in the National Indemnity case. he was hired, the employee in that case was hired for a specific seasonal period. We also cited the American Safety case where they cite the Oxford English Dictionary and say that you have to have a defined period of employment in order for it to be considered short-term. Now, my colleague talks about the fact that we have to speculate into the future as what would have happened as a reason why it was not short-term, but I think it's the exact opposite. The fact that we have to speculate about what would have happened for months or years or 10 years on end is why it was not a short-term relationship. If your honors hire an intern from law school for the summer, it's fairly clear that their employment relationship ends after those 3 months. If your honors hire a career law clerk, it's an open-ended relationship that goes on to the future. Now, they could leave after a couple weeks, they could leave after 10 years. But the fact that there's not a defined period of time for which that relationship is intended to last is why it is not a short-term relationship. The nature of the work being performed is not dispositive because the definition of employee is so broadly defined as anyone who is working for the employer. The reason it's so broadly defined is because this is a CGL policy and that claims by injured workers and employees fall under the umbrella of workers' compensation. Now, the fact that Mr. Cook did not receive workers' compensation may allow him to sue Gator Creations in the underlying case, and there may be an issue about whether Gator Creations can raise workers' comp immunity as a defense. But it does not mean that Old Dominion's policy provides coverage for that underlying claim. The evidence shows that Mr. Cook was working 8 hours a day, full-time, 40 hours a week on one project, and then immediately began splitting time on another project, which was expected to last a minimum of 6 months, but ultimately took 9 months. And that there was no gap between those two, working, again, 40 hours a week, every week, not the specific days that he was called in. He was there every day. He worked a full day, and that simply is not short-term employment, especially because the testimony shows that they were looking for additional jobs in the future, and that Cook would have been continued to be employed by Gator Creations on those jobs in the future. And because we have to necessarily speculate as to how long this employment relationship would have lasted, the mere fact that that speculation exists is why this is not a short-term employee. If this court is looking for an easy definition of that, the cases point to the fact that we're looking at either a fixed period of employment or an open-ended period of employment that may last an undefined period of time. The latter is what we have in this case. And so under the clear terms of the policy, our position is that Mr. Cook was not hired to fulfill seasonal or short-term workload conditions, and therefore this court should reverse and remand for judgment in favor of Old Dominion, finding that its policy does not require it to defend and indemnify Gator Creations in the underlying action. And if your honors have no further questions, I just want to wish